Where's Senator Sears?
I thought I was here. Somebody.
You're not on video.
Oh, my goodness. All right. Well, I didn't realize you couldn't see me. So anyway, what we're going to do is try to get through this meeting this morning, calling the Senate Judiciary Committee to order. We have budget issues up, and I don't know if Matt Valerio's available yet. I'm hoping that we can be brief on the budget issues and people can send us documents. The only one I have a document from is Chris Fenno, and regarding the budget, and it's kind of hard to follow budgets without a document. So maybe you can briefly state the issue, and then we can take it up next Wednesday, once we have a document with what you're asking for. Is that fair? To the committee?
Yes.
Yes.
Yep.
So if people could submit those to Peggy by next Monday, that would be helpful. And then we can get them out and look at them and schedule a more formal discussion with the documents, with your asks.
Do you want me to try and get those documents up now, or?
No, that came in the only ones that what Terry Corsones has the study, the e-filing fee study committee status report. That's good. And then Brad Meyerson and Chris Fenno and Sarah Robinson, we had those earlier, I believe.
Yep.
All the others, I think we should put them up for next Wednesday, if you could.
Okay.
Okay. So why don't we start with Matt Valerio, just maybe briefly talk to us a little bit about what you're looking for, and then we'll do a more formal discussion when we have the documents.
Well, I don't know at this point that I'm looking for anything in particular.
Okay.
We have, we received some information from administration late yesterday after hours, looking at an 8% budget cut for fiscal year 21. And to begin with I guess they're going to be effectively budgeting quarterly. And so we would be looking at, almost a $400,000 budget cut in the first quarter, and it's like 389 or 369 or something, and then to continue throughout the year, and with the hope, I think, that there are going to be changes in revenue that are going to allow us to readjust as things improve throughout the fiscal year. And what I've always said about this situation is that the biggest concern I have is the wave of deferred cases and delayed cases and the like that are going to start to come forward in the next fiscal year as we start to come out of the virus situation. And for us, what that means is that we've got to be able to have the people on the ground to do the work, whether it's, whether we can do a bunch of work by video, or we do it, or we're doing it in courtrooms, my guess is, or somewhere else. I need the people to do the legal work. I saw that the court has asked for about $12 million in video technology and the like, and run it by our people. And, everything is moving very quickly right now, but I don't know that we're going to really need anything to deal with that. As you know, we respond. We're always the ones who respond. Whatever somebody else does, we have to respond to it. If there are more state's attorneys and there are more cases, then we've got to respond to that. If the court does some kind of thing that requires us to change the way we do business or respond by, if they have more judges or more judge time, then we've got to deploy lawyers in that area. If they use video, we need to be able to come up, to speed and address that. And I think as far as the video stuff goes, we're perfectly able to respond to that as we sit right now. The biggest concern I have is an attorney and investigator time and being able to retain people. As you know, and I've said this over and over and over again the last few years, have an extraordinarily difficult time now hiring people and keeping people. And I'm going to try to do the best I can to make sure that we do not have to suffer pay cuts or even pay freezes. But, if there's an 8% budget cut, there's not much that you can do when the vast majority of your budget is personnel costs. One of the concerns that I do have is as we move to doing more work on video with the courts is dedicated space within offices so that you can have those hearings and not be in court. As of right now, most of our offices are very crowded, and we don't have any spare space to do anything. We were addressing that up in Franklin County, but that was going to be our proposed budget, which for 21, which is, I guess, is out the window at this point, would have addressed some of those needs, and with some shuffling in Chittenden County, moving some positions into Rutland and some into Franklin, we were able to deal with some of that stuff. In some of the other offices, it might be more difficult, but we don't know exactly what that's going to look like yet. One of the good questions that came from our staff meeting earlier this morning is, where are the clients going to be? And I don't know how we quantify that from a dollar standpoint. The only other concern, because we have 50% of our attorneys are contractors, conflict contractors, who are independent contractors. The quality of their Wi-Fi for those who are in the Northeast Kingdom and in other rural areas is not good. And then you've got the issue of their own equipment, and I think we can help them with the equipment, but the Wi-Fi for some of them is problematic. I know that we have some people literally who are still getting onto the internet via dial-up. So when we ask for what's a request for money for this, for me, the biggest issue is making sure that I have intact the group of people I need to do the work. And the other parts I think we can accommodate. But if we end up with, I can't cut contracts. I can't, because they're already grossly underpaid and there's not really enough of them, but I can't fill what I have right now, that if I were going to do it ideally. And then secondarily, I have positions that are open and now frozen because there's been a hiring freeze in the staff system, but I need those positions if I'm going to deal with a wave of people. And to me, it's not about asking for more money. It's just keeping everything I have. If I could make everything I have be intact going forward, could probably handle it, putting one foot in front of the other. But it's not just how much more money are we going to get. It's how much money are we going to end up losing going forward.
I appreciate that Stephanie Barrett's here. And Stephanie, are you able to continue to work with the various folks that are here in presenting something both for the skinny budget as well as the COVID-19 funds? For example, I believe the Judiciary put funds in to buy laptops for everyone.
So the judiciary asked for FY20 in the BAA supplemental, the COVID supplemental BAA
Yep.
is in at 4.9, and the vast majority of that is technology for remote access and safety to resume operation. And so there was discussion that both the Defender General and the state's attorneys would have subsequent asks to keep up with that. And so in listening to Matt, the ability to actually estimate the costs and to track the costs that are COVID related, where those can be covered by the CRF dollars, is very important, because the CRF dollars have a very hard deadline of December 31st, by which they have to be expended. The work has to be done essentially for that. COVID dollars can't be used to budget beyond December 31st. And so the trick is the cost that can be attributed to COVID activity, the closure of the courts, and the subsequent backlog and the ability to catch up with that backlog, and the need for technology to do remote, those types of costs, people need to make an effort to track those costs and make estimates for what those investments need to be. And then we feel pretty strongly that those are permissible expenditures. Also looking at the FY21 budget, the instructions that went out are the first 3 quarters, the first 3 months, the first quarter of the 21 fiscal year. That bill is intended to just give enough spending authority to start the fiscal year, and the big bill would be developed in August and September for the remainder of FY21. By then, we'll have a much clearer picture of what the revenue landscape looks like. And right now, that looks like it's significant down, to the extent that there are ongoing COVID-related costs in there, and we have CRF capacity that might help to some extent. But the larger conversation about the entirety of FY21 will happen in that August bill. The ask that went out from the Finance and Management last night is in the target they put in for 23% of general fund, and most of the criminal justice is very heavily general funded. Let us know if that 23% is not a realistic amount for those first 3 months. And I would do that in a bifurcated way, first 3 months with and without COVID. And so the 23% for your normal base operations versus the 23% trying to cover everything, including your COVID related expenditures. And I'll stop there for questions, but I'm hoping that's a little bit helpful to people.
Let me ask though, we've been tracking the COVID expenditures so far, and we were well positioned to be able to do what we needed to do before the COVID situation. And we've spent next to nothing relative to our total budget in addressing the COVID situation. You know, I'm not one really to, you know, quote unquote, make up a COVID.
It's not a makeup. If there are additional resources you need for a period of time to catch up with the backlog that is COVID related, that's a COVID permissible expenditure. And especially going into 21, because that budget hasn't been built yet. And so there is a restriction on using COVID if your base budget that's already been passed can cover it. But if the 21 budget has not been created yet, and so to the extent that you're catching up in the backlog in July and August and need, you know, additional, to the extent that you can fill them, additional positions or contracts, those types of costs should be attributed to the CRF fund, we believe. And also, if you need remote technology, if there's laptops and things like that, or technology that needs to be brought up to align with the judiciary, and those can be deployed in this time frame that we're talking about, those would be the types of COVID expenditures that we would be expecting to see borne on the CRF side of the ledger, as opposed to your regular base budget side of the ledger.
All right. I don't think the technology is going to be an issue at all, to be frank. But
well,
the the other side of it, obviously keeping everything intact and making sure we have the people to do the work is I guess the side of the ledger to focus on going forward.
Thank you. Yeah, Jeanette.
I thought Matt said that you said that that the technology would be an issue for many of the contract people, and if there might be a way to put that into to somehow upgrade that.
Yeah, I mean, it will be for some, but I know that right now the contract people have been doing the work, remotely, and everybody seems to have Wi-Fi. The issue is in the spots where you've got attorneys, you're going to have maybe a couple, but
Okay.
and then you've got the place where there's poor Wi-Fi availability, and that's not going to be solved by this situation, I don't think.
Well,
but I do think that the tech side of it is the least of our worries, to be honest. But I can survey the contractors and see what they need.
do you think it's more realistic, Stephanie and Matt, and maybe anyone else, Josh and Pepper and all the others? Is it more realistic to look at this in 2 weeks than next week?
So there's going to be multiple, I assume there's going to be multiple vehicles for these CRF appropriations. If there are known FY20 expenditures that people feel confident about the expenditure amount, FY20 meaning through the end of June, that people feel confident about the expenditure, those types of things could go into the budget adjustment, which will probably be in the Senate Appropriations Committee next week. But there will also be that skinny start bill, which will offer an opportunity. There will be standalone vehicles, we assume, that may offer opportunities for appropriating the money. So that the timing is the absolute timing is that December 31st date, and sort of working back from that and understanding what type of activity has to happen when for that work to be completed by December 31st is one guidance that I would give folks. But I think, if extra time is needed, I don't think that means that the ability to appropriate the money is lost. I just think it will happen in a subsequent budget vehicle.
Senator Sears?
Yeah. I'm trying to deal with, I've just got invited to an appropriations committee meeting at 10:30 this morning. I don't know what's going on. This is.
That's at 1:30 today.
Oh, okay. It says 10:30. So I'm just
I don't
gonna.
know what that is either, but it's at 1:30.
She must have made a mistake. Thank you, Stephanie.
May I ask
Senator
Stephanie a
White,
question?
yes, please.
Stephanie, did you say that on the CRF that it has to be spent? Anything has to be completed? I mean, like there are things...
we had a group of state fiscal officers had a call with Treasury official on Monday. It was not, they were, the gentleman was giving, what are reasonable arguments for supporting the CRF expenditures we're making, and the sort of clear due to COVID expenditures. And one of the big questions was, what does it mean that it has to be expended by December 31st? And he was saying from their point of view, it means that the dollars are out the door and the work is completed, not the dollars are out the door and the work will stretch for months after that. And so that was the most disappointing part of the conversation, is that that's a very hard date from Treasury's point of view.
That certainly does away with our ability to improve our connectivity and broadband.
It will depend on the nature of but
okay.
It's a conversation. Yep.
All right, thank you.
All right, Joe.
Matt, you had floated me a question last night, and I don't have the answer. I don't know if you wanted to ask that question here with the folks that might be able to answer it.
Yeah, I did, and I've got to remember what the question was because I've had about
It
8.
had to do with filing fees and the care money.
Oh, yeah. This is really probably for the later witness, but I happen to be on the committee involving e-filing for the VBA, and I wondered if because of the issue of social separation and remote filing and the like, whether or not the COVID money is available for the court's e-filing fees, at least for this and for the next fiscal year.
There is the discussion of that. Stephanie, did Steve Klein write that memo or did he get that memo? I can't remember now. I'm overwhelmed.
I don't think he's written a memo yet. I know that over the weekend, Catherine and Steve shared some, various correspondence. So I will double check on that. I wasn't
I think
working
there
on
was
the
something
feed.
about 175,000 could be
Oh.
covered by COVID funds for the e-filing.
Yes, that would get you through, I believe, either January or March 2021, or January 1st, 2021, December 31st. I can't remember. He was also costing out between January and March on the general fund side. I will dig up and find out. I didn't see an official memo. I saw emails
Okay.
with
I
numbers in it
thought
back and forth. Yeah.
Like I said, I
Yeah.
think every one of us who sits on this committee and serves in the Vermont Senate is overwhelmed by constituent, by other issues. I've never felt as the inability to work remotely on these types of issues is very difficult. And frankly, I'm overwhelmed, and I'm sure you all are as well, trying to lead either departments or agencies or deal with your problems. I'm going to move to Josh Diamond to hear a little bit about if the Attorney General is overwhelmed or not.
Thank you, Senator Sears. Joshua Diamond, Deputy Attorney General, appearing on behalf of the Attorney General's office. I'm joined today by David Scheer as well. Senator Sears, members of the Judiciary Committee, thank you for this opportunity to talk a little bit about the budgetary impacts caused by COVID-19. And not dissimilar to the Defender General, we have really seen a significant increase in the legal demands for our services, whether it be by Vermonters or our client agencies. We've been able to meet that demand within the confines of our current budget, but we anticipate that those demands will continue. And we are concerned, while we are able to meet our obligations with our existing budget, if there are cuts, that will put a lot of pressure on us. By way of example, or several examples, we have created a rapid response team right out of the get-go when this crisis became apparent, to address the various questions from the public, from law enforcement, from our client agencies about compliance with the various executive orders. And what that's entailed is really direct contact by our line AAGs, but also all the way up through to the general himself, meeting with businesses, meeting with law enforcement, talking to church leaders, multinational corporations and their general counsel to convince them, to educate them, to cajole them to do the right thing, to comport with the executive orders, and to ensure the health and safety of all Vermonters. And we've been successful. We have not had to litigate over enforcement of the executive orders, but we anticipate that that's not going to last forever. As I'm sure you all can sense in your communities, there is a lot of anxiety of the economic uncertainty. I think there, in some pockets of our communities, a lack of patience. And we have seen in a number of our sister states numerous challenges to these executive orders. We expect we will be defending those in due course, and that will require resources on behalf of our office. Just to give you some statistics, our rapid response team has addressed over 170 inquiries from Vermonters about compliance with the governor's orders. We've received 15 referrals from law enforcement. And as I said earlier, that all involves direct time-consuming contact by our staff to get compliance throughout the state. We also engaged in a vigorous activity by calling over 41 lodging operations when those executive orders came out dealing with compliance, whether it be Airbnb, Expedia, or just the mom and pop inn owners across the state. Another indication of the work to come that we anticipate is in our criminal division. We have seen a very disconcerting increase in cyber tips related to our Internet Crimes Against Children unit. That's the unit that investigates child pornography, child sexual assaults. We've seen a 200% increase year end over end from last year. That will require resources beyond certainly the 12/31 deadline. We will need to deploy resources to investigate those potential crimes. Our public protection unit has also been busy addressing price gouging. We've received over 110 complaints from consumers. That also involves from our investigators, from our attorneys, direct contact with those Vermonters to find out what's been going on, to reach out to the businesses who've been alleged to engage in price gouging and to get relief for consumers. In one case, we were not able to get that relief by that direct educational conduct, and we actually went out and had to get a preliminary injunction. A distributor of PPE face masks was seeking a 2,500% increase in his cost and trying to sell masks to healthcare providers, and we were able to accomplish that recently. Our public protection unit also has a civil rights unit, and they're seeing a spike in inquiries. Concerns about employee rights, about access to PPE, how returning to work could impact their disabilities, family medical leave. And as in any economic crisis, we fully anticipate that those who are not able to find new employment quickly will be pursuing their civil rights claims to the extent that they feel that they have been unlawfully let go or impacted. And we expect that unit to see an uptick in business as well. And then even in areas such as our general counseling services, we have been asked to help all state agencies on a number of contractual matters, whether it be getting access to essential supplies, contracts to construct and operate new medical facilities to anticipate the surge of activities, addressing questions about contracts that need to be canceled for force majeure. We have received a lot of activity in those areas, and we fully anticipate there'll be litigation that comes out of that going forward, whether it be non-conforming orders where we need to seek relief affirmatively, or defending disgruntled contractors where force majeure has been invoked. Also, our Agency of Human Services has seen a significant uptick in business, if you will. Our Department of Health attorneys have been working around the clock to provide general counseling services to the Department of Health as they address the myriad of issues. And there are backlogs in this division as well. Our Department of Children and Families anticipate a backlog of at least, I believe, almost 50 cases. There are about another 99 that need to be filed coming out of COVID-19. So that's going to put a lot of pressure on us. I assume the Judiciary as well, possibly the Defender General's shop, who will be defending in many of those cases. We've got backlogs as well in guardianship proceedings and in mental health hospitalization orders. So the work will continue. It will not slow down. And we think we can meet those demands in our current confines of our budget. But if there are cuts, that may be exceedingly difficult to meet the demands of the state going forward. So I'd like to turn that over now to David Scheer, who can talk a little bit about what's going on in the pretrial and diversion programs in our community justice unit.
Okay.
Sure. Thank you very much, Josh and the committee. With respect to the pretrial services and diversion unit, there's a couple different things going on right now. There's obviously, along with everybody else, significant adjustments have had to be made in terms of how we deliver those services. They're mostly being done remotely, and frankly, there are some challenges, especially on the pretrial services side, with getting people matched to programs that they need. The idea of a warm handoff, which is something we talk about a lot, is quite challenging. And so we've had to be inventive about how we do that. In particular, with respect to budgeting and diversion, there's a significantly lower collection of diversion fees as compared to a similar time period last year. There's two reasons for that we perceive. Partly it is a lower rate of referrals, but much more significantly, even if you account for that, there are fewer people able to pay. And I think the reasons for that are probably self-evident. We are entering into a very difficult time. People are losing work, losing employment, and there does seem to be an increased need. Just for a brief background, diversion fees operate on a sliding scale. So there is a diversion fee rate set by statute, but the programs do have the authority to make adjustments on the basis of need, and that need is simply greater than it has been in the past. And so diversion programs are dealing with, as a whole around the state, fairly significant gap in funding, and that's something that's that programs are going to have to account for going forward, and it is going to be a squeeze.
Again, next Wednesday, hopefully you can get any budget type requests to both Stephanie and Peggy Delaney. So by Monday, so we can take them up next Wednesday and take a good hard look at what those impacts might be. And we'd appreciate that. I think we're kind of combining both issues here, the issues facing the court system when Vermont loosens restrictions, the same issue. I mean, you know, you're going to have a number of people coming into court who are going to overwhelm a system that is already at a breaking point, and how you're going to do it remotely. I don't know how many of you saw the Judiciary's proposal, but it's broken into three different pockets. One is the COVID-19 direct related expenses. The other is like a for the FY20 budget adjustment, and the second is the FY21 budget needs. So anyhow, any questions for David or Josh? Thanks so much. I'm going to take up with John Campbell and James Pepper.
Thank you, Senator John Campbell, Executive Director for the State's Attorneys and Sheriffs.
You know, we're disappointed we can't see you, John. Do you need
can't?
technology? Yeah.
All right, hold on here.
Do you need new technology? Oh, it's so nice to see you.
There I am.
My
I am
gosh,
there.
yeah.
There, all my hair growing. I feel like I'm back in the 70s. But then I
I
got
know.
talk to you about that.
As long as you still got electricity for your blow dryer.
Yeah, I do, of course.
Not close to the
Well,
70s.
that's a little joke, because John and I had an apartment together at one point, and he was always concerned about the electricity for his blow dryer.
Had to make sure, like Jeanette, had to make sure that hair's just right. Anyway,
Pepper and I don't worry about those.
First of all, I also want to say welcome back, Senator Benning. Glad to see you there and active with the group today.
Thanks.
I understand that you do not want to go into the specifics of the funds. We did submit a memo regarding that, and we could wait till Wednesday. But I think the most important thing to understand, and which I know you do, is that the court system, the criminal justice system in Vermont, as well as the rest of the country, actually the rest of the world, the articles I've been reading, is really facing a a dilemma that they've never seen before. How do we deliver criminal justice, and how do we ensure that the rights of the defendants are protected, and that we keep our the Constitution sound. And it's, I think the only way right now, in talking with the courts and knowing how large the backlogs are, is that we have to understand that we will have to do things differently. And right now, the only way to do it differently is to do it through basically remote justice. And it's going to be difficult to work all those things out, especially when it comes down to jury trials. As you know, the defendants always have a right to confront the accusers and also witnesses. So you're going to have issues that are going to come up regarding social distancing. And in the last week, because we have also realized this as soon as we heard that the courts were going to be closing, one of the things I did was to reach out to ADS to discuss the possibilities of remote justice, and to see what their recommendations were, and also to go through what we have currently as our resources. And we've met with them, and they were concerned mostly about the security of the systems. Again, not just our system. I'm sure it's also Defender General's and also the courts. But the fact is that anytime you're going to use any type of IT and it remotely, you're going to have to make sure that it's all secure, up to date. And that goes with our management systems, everything. So we have our proposal to you. It sets out what changes we need to do, but again, we'll discuss that next week. However, I do think I agree with the court, and I think the court did a great job in putting their package together. I do think that if we right now do not look at these needs and understand that we're going to have to attack this backlog problem by remote and dealing with things in ways that we've never done before, we're going to be in really big trouble. If you recall, several years ago, we had a huge backlog in Franklin County. And it took adding additional personnel, adding additional judges up there to finally get that in hand. And that's nothing compared to what we're facing right now. So if we let this slip through our fingers, this problem is only going to get greater. And one of my big concerns is the fact that if the federal government does not continue with the COVID type funds or the CARE funds, then we are going to be either looking to the state, which I know the state doesn't have the money, and it's going to be very tight going forward for the next 3 to 4 years. Then we're going to have a serious crisis, even more than what we have now in the judiciary, in the criminal justice system.
I don't think there's any question that without federal help in terms of the next bill, without that help to the states and the local governments, we're in deep, deep trouble. Looking at the fiscal state of Vermont and any other state, how you're going to run schools, how you're going to run courts, how you're going to run, you name it, how you're going to operate. And so again, I appreciate your putting together whatever you can to try to help us sort this out and do our best to struggle through this. You're raising one issue that Matt doesn't have as much as you do as state's attorneys. Matt Valerio can move people around, especially remotely now, to deal with different counties like Franklin County, which is overloaded. But you have a much more difficult task in doing that, since you have 14 independently elected state's attorneys. And so if there is there isn't that much going on, and for example, Orange County, it would be tough to move the personnel to Franklin County.
And we're already
have
down.
you given any thought that remotely it would be much easier for people to
We have actually, and that's part of the proposal, but because we're already down six deputies right now, going into this year, or currently we're down six people. And we have thought about it. And, one of the other things that I think, you and I, we both, over the past few years, have been struggling with let's say those video arraignments when we're talking about that. And, I know Matt was very concerned about the confidentiality and, so that the systems that we had in place were not sufficient. And I thought, and I agreed that I thought he was right. And there's not been much change. And that's the only way we're going to change that is through, I believe, the use of these COVID funds. And at the same time, provide us with the manpower or, the labor force that we will need to be able to shift some folks to let's call it the hotspots. And what we thought about was to go along sort of the same thought that, or same way Matt does with the independent contractors, so that we could have some contractors that would be able to either remotely, or if there was a case where you had to be present, then they could possibly travel down to a different county. But they would be at the disposal to go, or I should say, not the disposal, but the direction to go where the demand is.
Good. Next, are there any questions for John or Pepper about where we're headed? Jim Baker and Matt, yes. Do you have thoughts from correct? I mean, you don't have control over your population as much as the others might, but do you have some budget issues that we should be looking at?
Yeah. Good morning, Interim
Good morning,
Commissioner Jim Baker here. Sorry I couldn't join you by Zoom. I'm on the phone, and hopefully you hear me okay.
We can
I
hear
did
you
ask
fine.
Matt. I did ask Matt to join me, Senator, because
I think Matt is
he-
he's muted, and we can't see him, but I know he's here.
I am here, yes.
he understands the numbers much better than I do. But as far as the current budget and the budget adjustment, we've put together a number that's in that budget adjustment for this year on funds that we have spent on COVID-19. As you all have heard me talk about our response, and we have spent a fairly significant amount of money on managing the virus and continuing to manage the virus, and that's been submitted in the budget adjustment.
Okay.
I think looking at the skinny budget, I think this guidance did just come out as Matt talked about earlier. The guidance came out, I think, yesterday, and I just got the information from my Matt here a few minutes ago. It looks like the skinny budget for the 3 months, we'll be looking at just, I think Stephanie talked about this earlier, 23% of our current budget to move forward in fiscal year 21. The 8% cut, again, it's too early to react to that. And, but an 8% cut for us in that 21 budget is about $12 million. I mean, that's devastating. I mean, we've talked about this in the committee before about, the last 4 or 5 years have been very tough budget years. We're about 96, 98% general funds. The general fund's going to take a hit. It's going to be very, very difficult to deal with. And, I don't think we're prepared to talk about that until we really have a solid number moving towards that 3/4 budget that'll start in October 1st. But obviously, just throwing out a dollar figure of $12 million is devastating. When I saw that,
What worries me is you have a surge of people coming in,
correct,
new entries into the correction system
we
as
have
a
no
result of the opening up of the
Right.
court system. And
correct.
that worries me. And the other thing that worries me is the easy place to cut is in the community-based programming that you need to keep people out of prison, or to have places people to go to out of prison. And so all of that gets thrown into the wind as we spend the money on bridges.
You took the words right out of my mouth, Senator, because that's what I was going to go to next. my immediate reaction to that is the work that's been going on, the conversations we've been having. You and I started this conversation briefly at the beginning of the week and the end of last week around really working on focusing on that community-based correctional system. And, that's exactly right. You can't, if you got X amount of people in jail and you're having a hard time figuring out ways to cut that number down, you've got to deal with the people that are in the system. And that could really impact creative thinking around better managing folks in the community. And we've been doing a lot of brainstorming internally. I think we're narrowing it down to make some suggestions and working with CSG on that. And this could be devastating to that whole process. It could damage the system for years to come, and not have the outcomes we're looking for, which is, again, it's not always about saving money. It's about taking good inmates and turning them into good citizens through good programming, good supervision, and good supports. So, it's early for us to talk about that, but, we'll pull something together and make sure we get it to Peggy by Monday, kind of outlining and following the outline of what the judiciary did. So,
Well,
Matt, anything to add? Sorry, Senator.
No, I mean,
I just want.
no, go ahead. Matt, did you have something to add? Matt, did you have anything to add?
No, not much beyond what Commissioner Baker has said. No, we're looking at the Agency of Human Services. I had a call with them this morning about finance and management's guidance and getting that skinny budget put together in the next couple of days. We could certainly get some information over to all of you by conversation for next Wednesday.
Great, thank you.
Sure.
One thing, what are the numbers today in incarcerated population?
Yes, I'll give you yesterday. I didn't.
Well, yesterday's fine. Yeah.
1370.
Wow.
1370 in custody. I will tell you that though, we are seeing it's slowly sneaking up.
Yeah.
We over the last week we've seen the numbers go up, and I'm really asking the staff to take a look at what those numbers mean if they're in detention. We are starting to see some fairly serious cases. I mean, I think the state police has had 4 homicides in the last month, and we're starting to see a little uptick in some of the folks we supervise around domestic. So we're trying to figure out what that uptick is. And I will just reemphasize what you said, Senator. I think when the system rights itself, we've got to be prepared to understand what that number is once the system starts writing itself and how it affects us as to who we get into our custody. So 1370
Totally
yesterday.
agree. People are getting angry.
They
we
are.
see it in our emails, and most of them don't email their senators or representatives. But when
Right.
you see it in your emails, the anger and people, it's out there, and people are getting itchy. They're having quarantine fatigue, I think is the name of it. And some of it will obviously end up in the criminal justice system, unfortunately.
So we'll continue to work with you and get that stuff for you next week, sir.
Falco, I don't know how much you want to add to this, but we wanted you as part of this discussion of what happens next and how we keep the momentum of reducing our prison population.
Yeah, thank you so much for the opportunity to testify. And I think this is going to be a situation where the commissioner and I are singing from the same songbook in terms of the need to be supporting our community-based providers that are helping folks as they are being released into the community, and also helping folks so they don't get incarcerated in the first place. So in many respects, what I came here today to talk about is we would recommend funding many of the things that were recommended by the Council of State Governments in their justice reinvestment recommendations in the first place, which is standing up our community-based systems, also looking at things like helping the Department of Corrections with some of their needs around data collection, but largely trying to make sure that people have the reentry supports they need, especially as we're seeing these reductions in the number of people that are incarcerated, making sure as people are entering into the community that the programs are in place and the providers can be creative and adaptive to those needs in these really trying and unique times. And then also supporting the department in making sure they have the resources they need to keep people safe within the facilities. We know that there have been expenditures to get those resources, and think we need to make sure that those resources are available now and for the duration of this crisis, because we know that we're going to need to be keeping people safe who are incarcerated for quite a while. So whatever funds are necessary to make sure people have the PPE, the sanitary equipment while incarcerated, and then also looking at expenses that are incurred from things like the changes in visitation. So allowing folks who are incarcerated to have the ability to maintain visitation over video calls. I know that's a change the department made earlier this year, but making sure the funds are available so people can maintain connection with folks on the outside and maintain their safety while they're incarcerated. So those are really kind of the broad strokes, I think, very much in line with what the department has been saying, but happy to submit something in writing, just kind of outlining the broad strokes of what we think would be really important.
No, that anything would be helpful, but I think it's important that we keep all of the criminal justice system together and not separate out people who rep like the ACLU and other groups. And which is I don't know if there's questions for Falco from anyone, but yeah, Senator Benning.
Actually, Falco, this is for you and for the commissioner if he's still with us. I am really concerned that we have people that cannot get plea agreements accomplished because the programming that's called for is currently unavailable. And for instance, I have a domestic assault person we're trying to get through the system, but because programming is not being offered inside the facility or outside, as far as I know, any kind of plea agreement I commit him to has an open-ended question as to when he'd be released. And I don't know what's going on to resolve issues like that. I'm trying to recall the name of the programming for domestic violence. I was going to say community I can't remember what the name of it is off the top of my head, but it's not being offered right now inside the facility. And yet corrections will not let him out until he's completed it inside the facility. So what's going on and how are we going to clear that logjam?
That question may be better for the commissioner, Joe, but.
Yeah, so Senator, we recognize this issue, right? And so you used an example of domestic violence and the importance of programming around domestic violence to protect the victim. I don't know exactly where this is at, but I can get back to you and I can make it part of the package we put together for Monday. But we are moving towards a process to start that programming internally without allowing folks through our front door to keep the mitigation going. So we are in the process of figuring that out. And I think we're pretty close to having a solution to it. In a bigger picture conversation, I believe that some of this type of program you're talking about needs to start in the facility, but continues outside the facility. And I think when you look at CSG's recommendations and my conversations with them, and in a quick conversation with the Senator Sears last week, the goal here should be that we have more robust programming on the outside and less on the inside. But again, when I take a look at a $12 million number, which may or may not be reality when it sets in, that kind of shatters your dreams about what you can envision a community correctional system looking like. So I don't know if that helps your answer or not, but we are trying to figure out soon how we can start programming internally, remotely, so we can move some of those folks along,
Commissioner,
especially in the more.
Yeah, I just want to remind my own committee, we were having this conversation prior to being booted out of the State House because
Right.
the programming was offered on a quarterly basis, which would
Right.
mean going into a plea agreement, the person has to wait 3 months before they can get it started. But now we're in a situation where we literally can't do a plea agreement because the person, for all intents and purposes, could be subjecting themselves to the maximum sentence and have absolutely no control over how they get out of the system. So I'm really urging that this problem be dealt with as quickly as possible because there are people that are hung up in the system. We just can't get them through.
I understand. And what I have to say to that, Senator, is we want to make sure we're staying faithful to the model of the program too, and we can deliver it in a way that stays faithful to the model. I mean, that's been the challenge, but I've heard you, I've got it, and it's been the conversation inside corrections, and I will let you know soon what the resolution to that is and when we should be able to start that.
Thank you.
Thank you. That's an important point that we should raise also, is any programming that has been delayed due to COVID-19, both in the community and outside the community. And I know much of that is also involved in diversion programs and other alternative justice programs as well. So if we can get an update on that next Wednesday, that would be helpful. Anything else, Falco, or any other questions?
I just want to say thank you, Senator Benning, for bringing that issue up. That's something that we've heard from a number of folks about, especially people who are incarcerated and are being held for lack of at this point. So that's something I'll be highly supportive of, and hope that the committee can find a way to help move that forward, so that people can get the programming they need so that they can be released. So appreciate you. I think that's all I have to say for today.
Thank you.
And I know that Judge Grierson is on the line, but I'm not sure we're going to get to the issues facing the court system, although we've kind of covered that. But I do want to ask Chris Fenno for some comments when, if she's available. And we would come back to you also next Wednesday, because I do want to deal with the e-filing, if that's okay, Chris.
Yep, that's fine.
Senator Jim.
Yeah, I'm sorry, Jim, go ahead.
Yeah, I don't want to cut in. I apologize for cutting in.
No, go right ahead.
I do have. I'm going to drop off the call because I do have to get off because of a drop.
Okay,
A
we
drop dead
certainly
time now, so.
understand, and well, hopefully Don Keelan will pay the bill so we can see you next time.
Excellent. So,
Stay well.
I apologize for cutting in again.
No
Thank you.
problem. No problem. Chris, go ahead.
Yes, I'm ignoring my phone because it's in another room.
Oh, okay.
So it's going to just ring a little bit.
I hope it's
thank you
not
for
from East
having me.
Callis. I've got this junk call keep coming from East Callis, and I've tried to get rid of it. But
Yeah. I think that might be it.
Yep.
Good. Thank you for bearing with me. I appreciate being here and having the ability. I did send an update, which now is going to need to be updated again.
Yep.
I feel like, sort of like what you said, Senator Sears, overwhelmed all the time because everything is so fluid. I have never seen anything this kind of crazy. So I had quickly redone numbers. This week we found out that we were hoping for the network programs that this FIPSA money that was part of the CARES Act was going to be about $190,000. When it actually got to us, it's 60, looking for my notes, it's 60 something thousand, and it's not anywhere near what we thought it was going to be. So those programs had given me their estimates on their cost, but I believe most of what I've submitted is through June of next year. So I'm going to have to go back to everybody and to my folks, and we're going to have to see through December 31st. On top of that, you know, we too got the skinny budget notification yesterday, and while we have 3 programs that are affected by that, one of them is the network programs. So not only are we a little iffy about what the special funds, their DVSV fund is going to produce this year, but we're also looking at that state general funds of an 8% reduction on that, the child visitation programs, and the child advocacy programs. Those are the 3 that have the state general fund line in our budget. So I just need to think about that for a minute to see if any of that might be COVID related costs. I also updated the And John Campbell, I apologize. I haven't even had time to talk to you or Annie about this, but in looking at what about $400,000 reduction in our special fund towards that program would mean, going through December 31st would really mean about $200,000, but it's about 4 positions for that advocate program that potentially would be lost because the revenue is lost. And to me, I think we can make a case that that is in fact COVID related. It's not general fund related. It's special fund related, which we all know how that works. I put some numbers down for the center because we are starting to be able to see what our increased costs were. We're trying to get back in our building, and right now we have cleaners 2 days a week. We're looking to expand that to 5 days after hours to have people come in and just do sanitizing it, even though we have a long laundry list of what we have to do to get people in anyway. But so we have those kinds of increased costs. What we haven't been able to get a handle on, we're trying to get our people that we furloughed back in, but the furloughed people, we are one of those employers that pays for unemployment when there are claims made against it. So we actually do, we will have hard numbers of what those furloughs cost us. And while it'll be less than if they had been employed full-time with us, we kept people sort of as whole as we could. We're paying 100% of their medical costs. And then we will get the bill from the state for the unemployment piece. So, so I'm going to work on those numbers right now. The total looks like it's about 1.2 million, but it will be less than that when we prorate it down through December. I am very concerned about victim services. I appreciate being able to hear you know, what's going on in other parts of the justice system. But, you know, for all of the justice system, and, you know, I always say this, so I know you know this, but, you know, there also are victim rights. And in order to offer services to victims, which is so important in our society, we need to realize that sometimes it's just scotch tape and, you know, crepe paper, it feels like. So we are trying to not sound the alarm to our grantees, but and to our staff. But I will be honest with you that we are very scared in a way that we weren't even 10 days ago going into this. So that in a nutshell, you can ignore the revision that I sent to Peggy before this meeting, and I will send another one by the end of this week.
Great.
And I'm willing to take any questions if anybody has any.
Any questions? You know, I just think that it shows how unrealistic it is to expect us to get along with an 8% cut.
Absolutely.
It's totally unrealistic, and but we don't. As a member of the Appropriations Committee, I know that the struggle we're facing is the loss of revenue.
Yep.
Every revenue, and this says a lot, every revenue source is down significantly, with the exception of alcohol.
Oh.
Alcohol is up.
Wow.
And I think it says a lot about our situation. I think alcohol was up by about 4% in terms of revenue in the last quarter, where everything, or the last, excuse me, the forecast is the only place where revenues are up. And we're in a dire straits, and without federal help, you know, and we're Vermont, supposedly in better shape than most states in terms of fiscal health. So it just
Right.
says.
I am still looking, even though the news yesterday was kind of bleak in the Senate, of the next bill that might go through.
Yeah.
We, I think I said this last time, that the first bill, the Violence Against Women Office and the Victims of Crime Office did have allocations in there for COVID-19, and those were cut out and haven't been put back in. Those would greatly, if that got back in, it would greatly help the state of Vermont.
Well,
who knows?
we are reliant on our federal partners here, and we need to have that dealt with soon.
And we are having conversations, as is, I spoke with Karen Trasgard this morning, and that we're doing everything we can.
Great. Excuse me. I'm gonna move on with all. Judge Gerson, did you have any comments that you'd like to make before we move on to the e-filing subject?
Thank you, Senator. Thank you for inviting me. For the record, Brian Grierson, Chief Superior Judge. I could only add to the comments you heard from corrections, the defender, state's attorneys. Obviously, the judicial system as a whole is going to be facing a significant backlog. We generally schedule 2 months ahead as a general rule, which means over the last 2 months that we've been in this emergency situation, we've literally canceled thousands of hearings. That doesn't involve thousands of individuals, but thousands of hearings. So that's one part of the backlog. We have had some filings in the dockets, minimal filings. We've obviously been focusing on emergencies. And so that's one of the great unknowns. Once we open up the doors, which is supposed to happen first week in June, we expect a flood of new cases coming in. And I think the only way that we're going to be able to address this is finding new ways of processing these. The defenders and prosecutors have not, for the most part, had a physical presence in the court for 2 months. I would expect that's due in part to a significant expansion in the use of remote hearings, both by video in the facilities, but also through WebEx and other platforms to conduct evidentiary hearings. And that expansion is reflected in our request to the legislature to be able to expand that ability to process cases remotely. We think that will continue. We think it should continue. We think it's been one of the silver linings in this pandemic, is to find other ways of processing these cases. We're going to need it. I won't spend a lot of time on it, but just to give you an example, and I'll have more information next week, because the Supreme Court is in the process of issuing a memorandum. I expect it'll be out by the end of this week, to try to set some priorities and guidelines to reopening the courts. So I will have more information, but just by way of example, I would think everyone would have to agree that the priorities are going to involve children, and they're going to involve the incarcerated population. And within those dockets, we expect the judiciary will have to reallocate its resources to focus on those dockets, meaning judges that are sometimes doing civil matters will end up assisting in the backlog in those dockets. And I think for this to be effective, somebody referred to the Franklin backlog a few years ago, and if this committee that was instrumental in helping with that backlog, that was one backlog essentially in the juvenile docket. But it took the combined additional resources for state's attorneys, defense attorneys, the judiciary, DCF to attack that, and we were able to do it successfully. So as we go forward in this process, it's going to need resources for all of the players, and at a minimum, a reallocation of those resources. And I'll leave the committee with this thought. If we have, for instance, in most courts, the juvenile docket operates, let's say 2 days a week. We're not going to be able to get through this backlog in the juvenile docket. And we anticipate once the courts open up and the families, the stay-at-home order is lifted, we're going to anticipate more things. But we'll never be able to attack that backlog if we keep the schedules the way they are, which means the footprint for the juvenile court will have to expand, which means state's attorneys and defenders, perhaps who are not presently doing juvenile work, may have to focus on that. And then the focus may have to shift to the incarcerated population. So I think it's going to take everybody working together and finding new ways of processing these cases to get through this backlog.
Thank you, Judge. Appreciate that. I think we'll, I know everybody needs a short break here before we take on the e-filing. If we could take a 2-minute break, please, just to have an opportunity to move away for a few seconds. And then we'll get right back with Brad Myerson, Michelle Childs, and Terry Corsones. Am I here, Peggy?
Yes, you are.
Oh, good.
No, and I just took the, while we're on the break, I shut your video off for a minute.
Oh, okay. I couldn't tell what happened to me. I'm glad I know I'm here. We're only going to have about 25 minutes, so I do want to hear from Brad Myerson. If Michelle, you have quite a bit to go through.
I can make it short. I
Okay.
think what you would ask me to do is just kind of frame it and kind
Yeah.
of go over the
If you could
history of how
frame
did
what
we.
happened since 2014, I appreciate that. And then Brad, are you there? You're available, right? You're ready. So then we'd go to Terry after that, and this isn't gonna go away. So don't feel like we're gonna finish it this week. there may be, unfortunately, the record on this goes back to 2014, and I missed a meeting of the Joint Judicial Rules Committee. I was the only member absent when this issue came up. And we have the minutes from that meeting. And Michelle's kind of going to go over some of that, but it was never, it doesn't appear that anybody approved anything at that meeting. So why don't we, as soon as Senator Benning was at that meeting, and Justice Dooley and Judge Morris were the witnesses. So Michelle, why don't we get started?
Sure. So what Senator Sears just asked me to do, and I realize we're a little pressed for time, so I won't go in all to our legal analysis and stuff. We can do that at some point if you're interested. But just from a timeline perspective, because I think one of the things is that people were like, wait a minute, people were just caught unawares about these particular electronic filing fees being paid directly to the vendor. So we were just trying to track down and understand how we got to this point. So as Senator Sears had mentioned, in 2014, the Judiciary had gone to House Ways and Means and specifically requested of Ways and Means statutory authority to allow the court to promulgate rules that would allow the court administrator to assess a fee for, among a number of other things, electronically filing court documents. So that was in 2014. House Ways and Means declined to do that. And they did not go with the language that was requested from the Judiciary, but they put something in session law instead in the fee bill that year. And I'm going to read it to you just so you can have context here. So it's the intent of the General Assembly that the Judiciary be authorized to fund the licensing and operating costs of an electronic case file and electronic filing system for all courts through, among other sources, the imposition of user fees on any electronic filing or electronic access to judiciary case records or both. The Supreme Court is authorized to submit to the General Assembly a specific plan for such fees, including the amount of each fee, the coverage of the fee, and the user action that will trigger the imposition of the fee to take effect once funding for purchase of the e-filing and electronic case file system is secured. So that was passed in the fee bill in 2014. According to the court administrator, that language wasn't sufficient for them to be able to go into negotiations with vendors to be able to proceed. And so there was nothing filed in response to that. So the court never came back to the Judiciary with a proposal for e-filing fees. Then you have, starting in 2015, you have, for a number of, since 2015, you have appropriations in the capital bill for the case management system. And so there've been, for the last 5 years, there have been appropriations for that filing system. Looking back at some of the presentations from the court administrator's office, it doesn't look like the e-filing fees were discussed in any of those presentations. I think it was more about looking at the case management system as a whole. But as Senator Sears mentioned, in June of last year, the court sent out to the bar the draft rules for electronic filing. And those were to replace the previous rules that had been adopted in 2010. The rule itself does not mention the amount of the fee or the fact that the fee would be paid to the vendor directly, but it does address e-filing fees. And then if you look in the reporter's notes that are part of the rule that is set out, the reporter notes does say that the fee is, quote, a fee to make an electronic filing or to effect service through the electronic filing system imposed by the e-filing system vendor. So that was in June. It was sent out to the bar. Then in December, the Joint Committee on Judicial Rules met, and they did review the rule. Eric has written up the minutes. There was a brief discussion about who would pay for the costs and expenses of the new system. And Justice Dooley had answered that the filing fees would cover the costs, and they talked a little bit about that. But that's all we have from that particular meeting. So that's kind of where we are now. There's issues here around, well, questions about, does the judiciary have the authority to be essentially imposing this fee on its own or without legislative approval? And we'll say that reasonable attorneys can differ on this one. I think there are arguments on either side. Generally, as you know, because you, the legislative body, you are, control the purse. And if you look in Title 32, it specifically says in Chapter 7, Subchapter 6, with respect to executive and judicial branch fees, and I will read it verbatim. It says, it is the purpose of this subchapter to establish a uniform policy on the creation and review of executive and judicial branch fees, and to require that any such fee be created solely by the General Assembly. So in general, it's the legislature's job to create, review, and adjust both executive and judicial branch fees with certain exceptions. And that's the subchapter where you have the requirement that the judiciary come to the committees of jurisdiction and present their fee proposal every 3 years. So that's that area of law. But of course, there's something else in there that kind of then throws things a little bit into question, is that if you look to another chapter, there is a provision that says that the court, under their general rulemaking power, shall establish uniform rules to govern the allowance of fees not specified by law for services and expenses in the courts. And so there's this kind of carve out. And so that's in a different chapter that addresses where you have where the legislature establishes the court filing fees. So if so the legislature creates, it's $250 to file a divorce action or things like that, and those are separate and apart from this one statute that's kind of a catch-all that says if it's not otherwise specified in law, then through its rulemaking and inherent rulemaking authority, the court does have some ability for allowance of certain fees. And then the question is what is the scope of that? And I think, and I don't want to speak for the court, but I think you've heard from the court administrator's office that they view it a little differently as part of their inherent administrative powers to control the courts and attorneys, and that they think the fee is a little different because it's being paid from the user directly to the vendor rather than it being a state assessed fee. Again, I think people probably have different views on that. But it's interesting because at one point it seems as though the court was seeking legislative authority to assess those types of fees through rulemaking and didn't get it. And then now they've done it through another provision through rulemaking. But regardless, you've got what you've got. And the question is, what do you want to do about it at this point?
Thank you so much for that final comment. So I want to make clear that we're really pressed for time this morning. This is not the end. This is the beginning of the discussion. I don't know what we do about it other than it's a bad precedent. I will say that. And to me, it's a bad precedent in that any branch of government could decide that it's going to set fees and then assess those fees to the public without any public input or legislative approval. So it's not just this particular incident, it's any that might come up. So Joe, you had a question for Michelle?
I have a question for Michelle, but the first thing I want to do is dovetail off of what you just said. A rules committee should not be in position of giving a yes or no to a request for a fee. And if there's any implication that judicial rules was responsible for saying, yes, you can, or no, you can't on this given fee, I would take issue with that immediately, because we are not normally a committee of jurisdiction to discuss financial impacts on people. And I don't want that precedent to be set by this, what I view in hindsight as a mistake. The question, Michelle, that I have for you, miscellaneous bill that I'm going to be talking about on the floor tomorrow is contains section 22, which deals with the automated filing for judicial bureau admissions on traffic violations. The current situation is when somebody makes an admission to a traffic violation, the data is entered into by hand by the clerk. This new section that we're bringing in through the miscellaneous bill says that those admissions could be brought in through the automated system. So the question now arises, does that admission coming in through the automated system entitle the judiciary to impose this fee for the vendor? And I need to get an answer to that question, not right now, obviously, but hopefully by tomorrow morning, so I can discuss that on the floor in case I'm asked. I guess that's the question.
Okay, I think that's probably a question for the court administrator, not for me, because that would have to do with the contract that they have with the vendor and what constitutes a filing trigger fee.
Okay, do we have Pat on today?
I am here.
Okay, Pat, that's a question I'm going to have to ask you. I don't know where you are in this schedule this
Well,
morning.
she's not.
I'm not a witness.
I think we need to either take that offline or at the end, but I want to hear from Brad first on the issue. But so if Brad, if you could, and then Pat, if you, do you want to briefly comment, Pat, or do you want to, what do you want to do?
Could I just make one clarification on the what I assume is a really good summary for Michelle? When the judiciary in 2014 went to Ways and Means requesting the use of filing fees to raise revenues to purchase the case management system, we were not talking about the kind of use fee that is the Tyler file and serve fee. We were actually looking to have the state collect and raise revenues to pay for the case management system. And when we realized that we were not going to be able to fund a case management system that way, simply because of the sequencing of it, we proposed different methods to the legislature. And so we ended up having that purchase be done through the capital bill. And the user fee for file and serve ended up resulting from the vendor we chose and how they did it. So it's just a clarification. They're two different things.
Okay, thank you. Brad, if you would go ahead, please.
Sure.
Well,
let me ask you this. In the limited amount of time I've got, I mean, there's a lot I want to say, but I think I'd rather ask, what do you want to know or what do you want to hear from me? Speaking as a private attorney who practices both in civil and criminal court.
Yep. I think we ought to go
I
through
sent
your
a detailed.
Yep, you did. And I think we have time to hear you.
Okay. I have
15 to 20 minutes.
Well, I'm not going to take that long.
Okay.
I've got very, very serious concerns about how this, first of all, how the vendor was selected, how the filing fee was adopted, the fact that that despite what the court administrator has said orally and in writing to this committee, there was never any advance notice to the bar about the particular fee. The training materials that were provided to the members of the bar through non-standardized trainings by Tyler, and I have heard this from other colleagues, largely made mention about collecting the fee, about how the system was to work, or nothing about the particular amount of the fee being charged. It was unilaterally decided by the court administrator and the judiciary that we were going to be paying a $5.25 filing fee per filing. There were other options available that were rejected, such as I mentioned in my written submission. In Rhode Island, they have a $17.50 one-time fee and a $3.25 technology surcharge. That would have been a lot easier, a lot more fair, not just to the attorneys, but this filing fee is not only for the civil division, but also for probate, the Judicial Bureau. A lot of pro se folks are going to have to pay this. Now, if you have, a will hearing in probate court where lots of people represent themselves, there have to be numerous filings. This is going to fall on the public. It's not just the attorney's oxes who are being gored. This falls on the public. And I, as a member of the bar, I'm particularly upset about the fact that this was sprung on us without notice, without any request for participation, without saying, hey, we want to charge a per pleading filing fee, rather than the Rhode Island example, which was available, or in Maine, where the legislature approved raising the filing fees. And there's a surcharge on fines. Now, the committee, I'm sure, is aware of the fact that at least in criminal cases, our clients have to pay an absurd amount of surcharges. In addition to the fines, there's a 15% surcharge on the fine. Our clients have to pay $100 to the special investigative units, and just on and on and on. As an example, why couldn't that investigative unit surcharge be reduced to $75 and take $25 of every fine collected and put that toward the cost of the Odyssey system? I gotta be honest, I got steam coming out of my ears. There are so many unanswered questions about who decided, without apparently any legislative input or oversight, and certainly without the input of the bar, that there was going to be this $5.25 filing fee. Why was this payment model decided upon rather than the Rhode Island or the Maine model, which those states also use Taylor technologies? I'm concerned, and this is something that Senator White questioned about. I'm concerned that this fee is such that it can create a barrier to court access in the civil courts and in the probate courts, particularly for pro se folks. Now, in a particular personal injury case, which I do litigate, we can easily have dozens of filings. Well, who's going to pay for that? It's going to ultimately be passed on to the client. In other cases in civil court and in probate court, where folks are represented by counsel, those folks are going to have to ultimately pay the cost of these fees, when a less onerous fee could have been adopted, but somehow the powers that be decided, well, it's going to be $5.25 per filing. It was mentioned earlier, or suggested, that maybe the COVID relief funds could be available for filing fees. I feel a little bit sheepish suggesting that, given that you all have just heard some fairly dire financial predictions from corrections and from the courts. But I would advocate that would be a very wise use of those funds. We are talking about the privatization of a public function, and that is the filing of pleadings, which are necessary in our civil courts, the probate courts, the Judicial Bureau. The fees are being collected for the benefit of the vendor. We pay the vendor, not the state. If the state were collecting it, it would be an entirely different situation. And Senator Sears, at the last hearing, you asked the court administrator a question that I didn't hear answered. And that question was, what protections do we have against Tyler Technologies, who provides the Odyssey system, unilaterally raising filing fees during the life of the 2-year contract? I didn't hear an answer. And I also, this isn't really the core of my testimony here, but I've attached emails and information that Odyssey's creating a lot of problems. It's creating problems in Windsor. It's creating problems in terms of the accuracy of the information that's being provided through it, in terms of checking a client's criminal record. I mentioned that in my submission. And during a recent Bennington County bench bar meeting held virtually for the very first time, it was discussed the fact that, well, come September 1st, Odyssey is going to be, quote unquote, rolled out for the rest of the state. And that couldn't have come at a worse time, because the courts will have been reopened for only 3 months in the middle of a tremendous backlog, trying to figure out what is essentially a new reality. How are we going to process cases? How are we going to preserve due process? How is everyone going to keep their sanity? We're going to be hit with this new electronic filing system, the collection of fees, a system which has so far shown, some real tangible problems. And yet there is no suggestion that, well, maybe we could delay the rollback a little bit to allow the courts on the western side of the state to adjust. It's just there's so many problems with the fee, how it was adopted, the fairness of it, why this fee model was selected. My request is, aside from the fact that should Ways and Means and other committees have been more involved in the selection of the contract, in the setting of the fee, that the contract should be renegotiated to, if it can't be canceled, it should be renegotiated so that a more equitable fee structure, such as Rhode Island, Idaho, or Maine, could be imposed, rather than a per filing, which I think is going to result in hardship for a lot of pro se folks and greater expense for everybody. Have a single upfront fee, and that's it. I think administratively it would also be easier.
Any questions for Brad? Brad, I appreciate your testimony. I'm also concerned in reviewing your testimony about the email from Ward Goodnow, the state's attorney in the United States. Goodnow. I should know his name. His mother is a senator. Regarding experienced significant issues with the new e-filing system. We are frequently not receiving copies of defense filings, blah, blah, blah. Those things need to be responded to at our next meeting by the court administrator, and your other questions as well. Pat, I know we're running out of time today to hear from you, but I think Brad has raised some significant issues, as has, I don't know if you've seen the memo from Ward Goodnow, but that does raise concerns as you roll this out. Are we going to see cases where inaccurate information, et cetera, particularly obviously in any case, this is serious. So I'm really concerned about that. I don't know what we can do legislatively, but I do want to start to begin to look at a bill that would prevent this from occurring in the future.
Well, Senator, would you like me to respond to any of this now?
Yeah, next week, if you could.
All right, and I'll just let the committee know that prior to being able to read Attorney Meyerson's letter, I did provide the committee with frequently asked questions list that's continuing to be developed. And that will help clear up a lot of the misunderstandings. And so I think that in terms of my testimony 2 weeks ago, rather than relying on the characterization in the letter, it'd be better to actually review the actual video. And if I just might say, when you do look at the frequently asked questions, it will address most of the issues raised by Attorney Meyerson regarding why this fee and not another.
I do believe that the judiciary went around the legislative process, and I have not ever, that I can remember in my years here, felt that situation was such that needs to be resolved somehow, and needs to be resolved with the bar and with this committee and with other legislative committees. We are actually functioning at the request of the President Pro Tem to look into how this happened to prevent it from happening in the future. I think that, you know, what it is right now. The ship has sailed, but I find it to be looking at minutes and looking at what we know from 2014 and the actions then, that this was done independently of legislative. And as Mr. Meyerson said, I totally agree with this could not have come at a worse time in the middle of a pandemic to roll this thing out.
With all due respect, Senator, we believe that it's come at the best time because it's only in the Windsor and Orange units that people can actually work on the case files remotely. So I know that the committee has a different point of view, but the judiciary is taken aback by the suggestion that we've purposely evaded appropriate legislative role. The judiciary considers itself working under its normal constitutional authority. Nonetheless, what we want to do is always collaborate and have a good relationship with the legislature. And I think, you know, in most instances, that's the way we have conducted ourselves. So we have to respect the court's right to administer the judiciary and follow the statutes. And at the same time, we like to do problem solving. So this is a clearly unexpected misunderstanding for us to suddenly be confronted with this. But we look forward to continuing to work with the committee and the legislature.
You see it as being confronted with this. I feel like we've been confronted with this. And the more I review it, the more I feel like you're expecting us to now rubber stamp, and I refuse to rubber stamp what was certainly in a situation where we were not partners in this. And I apologize because I missed the meeting of the Judicial Rules Committee that went over the filing, but there is no discussion there of the fee. There's no discussion of how Tyler Tech was going to get paid. And we still don't have an answer to the fundamental question. Is there anything that prevents Tyler Tech from increasing the fee? So hopefully next week you'll be able to answer that question.
I can tell you that now. It's a contract and it's through June 22.
Okay.
So no, they can't increase it between
Okay,
now and
thank
June 22.
Well, that's good to know. Terry, would
Senator,
start
can I have
with
one
you?
last?
Yep, sure.
One last thing. The fee structure was adopted without the input of the who are really the end users of the system, the bar and our clients, period. And with something with that type of impact, you know, good policy and reasonable prudence would have suggested that maybe the bar and the public should have been more involved in.
We'll pick up next
decision.
week with Terry Corsone. She's already filed, and she may want to add to what the Bar Association's response is. And then Michelle will continue to look at how we can deal with this. We've got another Zoom meeting in 5 minutes, so we've got to leave this meeting. Unfortunately, we don't often get a lot of notice on our next Zoom. Thank you all very much.
Thank you, Senator.